Good morning, everyone. I'm just going to wait for you guys to tune in. Happy New Year to everybody. It's been a very tough 2 weeks for me. So I'm going to, this is my first day back. So hopefully I can get through this. I actually lost my brother, my younger brother, who was only 37 2 weeks ago. So it's been a very emotional time for me. And so I'm going to try to get through today without crying. But I hope you guys have a happy new year. But just trying to get back to work to keep myself focused. Some people are saying they can't hear me. You probably need to just turn off your camera, turn it back on. I'm going to try my best. If I can't get through today crying, I'm going to have to log off. So I'm just going to do the best I can today. Happy New Year. So my name is Aisha Chidole, and I do immigration law here in the United States. I help people who have family immigration matters, humanitarian-based cases like VAWA cases, T visas, trafficking, U visas, naturalization, waivers, and removal of conditions, appeals, and stuff like that. A lot has been happening, so I just kind of want to talk about that. You guys should, I appreciate it, but, stop typing sorry for your loss, because I think every time you type it, it makes me a bit more emotional. So, but I really do appreciate it all. So the first thing I want to talk about is the full and partial ban and how that impacts those that are affected. I'm going to just go through the list really quickly, but if you go on my profile, it's also on my profile. So some of the countries that are on the full ban list with travel restriction, I'm going to try to get through everything, is Afghanistan, Burkina Faso, Burma, which is Myanmar, Chad, Equatorial Guinea, Eritrea, Haiti, Iran, Laos, Libya, Mali, Niger, Palestinian authorities. So those people traveling with like the Palestinian Authority document, Republic of the Congo, Sierra Leone, Somalia, South Sudan, Syria, and Yemen, right? And then the countries on the partial travel restriction list. So that's Angola, Antigua and Barbuda, Benin Republic, Burundi, Cote d'Ivoire, which is also Ivory Coast, Cuba, Dominica, Gabon, the Gambia, Malawi, Mauritania, Nigeria, Senegal, Tanzania, Togo, Tonga, Venezuela, Zimbabwe, and Zambia. So first, let me talk about consular processing for those of you who have cases that are being processed outside of the United States. If you're from those countries, with the limited exception, which is going to be very limited, so very few people are going to have this exception apply, if you're an athlete or if you have like a national interest waiver or something that you're doing for America, it means that they cannot process those visas. So whether that's your tourist visa, your student visa, your spousal visa, your fiance visa, so all of those visas are not going to be processed, whether you're in the full ban list, on the partial ban list. What does that mean? Does that mean that you cannot file for an I-130? No, that's not what it means. You can still file for your I-130. And once I'll get into that because there's an adjudicative hold on the side in the US. So I'll get into that. So you can file for your I-130, or for those who already have the I-130 or who've already filed an I-129F, like a fiancé visa, or are waiting, what it just means is that once and if this administration removes the ban, because they've decided that they're going to look at it every 6 months to make a decision of what countries remain on the ban, or what countries or what countries you're going to remove from the ban, or maybe even add some more countries on there, then you will be able to continue with your consular processing. The concern, of course, like what happened in President Trump's first administration, is that, of course, that created that backlog, but you keep your place in line, so if you're someone that had a priority date, you still keep your place in line based on that priority date, right? Once that is taken off. For those that are here in the United States and are wondering about the adjudicative hold, because adjudicative hold is different from a ban. So I want to make sure you understand the two different things. A ban would be for people that are outside of the United States that are trying to consular process and enter into the United States. Remember, if you already had your visa before January 1st, 2026, this is not going to apply to you. If you're someone who has dual citizenship, that you're using your other citizenship passport, this does not apply to you. And then for those of you that are here in the United States that have applied for immigration benefits, that you're under some of these countries, you are going to be subject to what we call an adjudicative hold. What does that mean? It means basically that, just hold on one second, because I wrote this note. There's just so much I'm trying to talk about today. So it means that USCIS will hold final adjudication of any pending immigration benefits. So that means you can file, but they're not going to make a decision until they go through this. They call it a 90-day examination period. That is what they're doing right now. It's a 90-day examination period where USCIS is going to conduct a comprehensive review, prioritize cases that they want to further review, and then schedule interviews or re-interviews if it is required. So what does that mean? In the next 90 days, they're not going to make a decision on your case. You know, if you had an interview scheduled, they will most likely cancel your interview. If they don't cancel your interview and you attend your interview, they will do the interview, but they will not give you a decision until they've been given the directive on how they want them to process those cases. You know, this news, of course, is new as of 4 days ago. So it's very hard. Nobody knows yet because 90 days hasn't passed. So we don't know how and what they're prioritizing. Their whole thing is, it's because of, let me see what it is that they said here. The hold is to make sure for security purposes that, you know, they're doing whatever security checks that they need to do. You know, of course, a lot of these countries have been placed on partial ban or full ban lists for things such as, you know, being having like a high rate of overstay, like on their visa when they come into the United States. So again, we will know in the next 90 days, so which would be April 1st, how those cases are being processed. And someone is asking, how does that go for VAWA cases? This applies to all cases. If you are from one of those countries, it means that they will not make a final decision. You can still apply and get your receipt, but final adjudication means final decision. They're not going to approve or deny, you know, unless this 90 days has passed. I want to say there was an exception if you have a crime of moral turpitude, but don't quote me on it. I'm going to have to go back because, again, as you know, because of what's going on with me personally, you know, I've been just trying to dissect and just digest all this news and just, you know, inform you guys of the updates as much as I can. Someone's asking, will this affect work authorization renewal? Yes, it will. Yes, you should still apply for your work permit renewal, but right now, remember what I just said, they are pausing a decision. They're pausing a decision for the next 90 days until they decide how they want to process those 39 countries, like how they want to process it. So for the next 90 days, before they come up with whatever it is that they're coming up with the level of security or extra scrutiny that they want to do, they're pausing everything, you know, with limited exceptions. For most of you that are from those countries, you will most likely not fall under the exception, okay? Someone is asking, can my daughter file for her aunt? No, a daughter cannot file for an aunt. A daughter can only file for a parent, and the daughter has to be a U.S. citizen that is 21 years or older. Someone's asking, is Jamaica one of those countries? No, Jamaica is not one of those countries. I just listed out the countries. So if you didn't hear it, you can go back to my live when I saved this live, or you can also Google the 39 countries with travel restrictions so that you can get the list. You know, there are 39 countries, so I don't want to relist the countries again. If you already have your green card, can you come Can you travel and also come into America? Yes, there is an exception for green card holders. If you are a green card holder already, this ban does not apply to you. You can come and go to, wherever you're traveling to. You're a green card holder. Again, this ban is, those who have green cards are accepted from this entry ban. You can come and go. Someone has asked me to talk about asylum. I don't do asylum cases, so I really don't talk about it. It's best to go to a lawyer who does asylum, so they can talk more about that. Does this affect 751 cases? Yes, it affects 751 cases. With 751 cases, can the individual still travel and come back as long as the individual has their extension? As long as you have your extension. What do I mean by that? Sometimes some people file the I-751 late, or the extension has expired, and they never went and got like an added stamp. If you didn't get an added stamp and you don't have, your extension has expired, I would not recommend traveling. So you want to make sure that you have your extension, which there are two ways you get extension. When you file for 751, you get an extension on your green card. Sometimes while your case is being processed, that gets expired. If it expires, the normal way is to set up an info pass, and then you go to USCIS and get an added stamp on that. Unless you have that and you know for a fact that your stuff has not expired, I would not recommend traveling. Something that confuses a lot of people, and I want to make sure that you guys understand that as conditional green card holders, is a lot of times people think that when they file for an I-751, they think that their extension starts from the date that they get the I-751. No, it doesn't. Your extension starts from the date on your green card that is the expiration date. So if your green card expired on January 1st, 2025, and you got a 48-month extension, your extension begins on January 2nd, 2025, even if you filed in 2026. So I hope you understand the difference. So instead of that 48 months, you technically only have 36 months. So you always want to count from the date of expiration in your card. The only time that you're counting from the date you receive it is when you get an added stamp, which an added stamp is your green card stamped on your passport, and it would have a 1-year date, which is the current date. That is the only time it would not be based on the expiration date. It would be based on the date that you got a stamp. So hopefully that's not too confusing. The second update that I wanted to talk about was for VAWA applicants, and this relates mostly to cohabitation. So USCIS has made some changes to certain benefits for VAWA and how it works. The biggest thing is cohabitation. Cohabitation means that you lived with a person that you're claiming abused you. In the past, this change was actually what the law was. The law, I would say in 2020, prior to that, 2020 and before that, was that you had to prove that you lived with your abuser from the time you got married and thereafter. Sometime in 2021, the rules changed and said you can prove cohabitation if the cohabitation was before the marriage, like meaning before the marriage, to sign the dotted line, or during the marriage, or, basically during the marriage. Now it has reverted back. It is very critical that you understand that you have to prove that you lived with your abuser after the marriage. It must be after the marriage. So let me emphasize that again. Cohabitation has to be after the marriage. The rest of the updates, it's not personally relevant to my clients because we do this already. The idea of why USCIS, made these changes is because there's been an influx of fraudulent claims, people filing fake VAWA cases, or whatever kinds of cases, and that is why I've always stressed about evidence. It is very, very important that you start strong application to reduce the chances of denial, noise, or RFEs. And so USCIS has basically emphasized that again and said, like apparently some people just file it with like a one pager, like, or something like that, or just fill out the form without really getting into it. But now USCIS is really, really wanting to see your comprehensive affidavit. They're wanting to see any credible evidence. It is very, very important that when you are a victim, because now you have an administration that is making the hurdle harder in every kind of immigration petition, whether it's a marriage-based case, whether it's a VAWA case, whether it's a fiance case. Basically, you really have to document your evidence, guys. Like, yes, in a normal marriage, you don't have to take picture of that, take picture of this. You don't have to have evidence of this happening. You need to have evidence. You need to start writing things down. If things are happening to you, you need to be able to write it down in your diary or wherever. Put the date that thing happened, so that when you are filing, you can give exactly what happened. Oftentimes, sometimes people will say, it was so traumatic, like, I've just blanked it out of my head, or I've just deleted all the pictures, or whatever it is. Please don't do that. Like, same thing, or people, they're unhappy with their spouses and what is going on. They delete pictures, tear things. Please save them somewhere. Go put them somewhere, put them on the cloud. If you need to delete them from your phone, if you're deleting it on your phone, make sure that it's on the cloud. You want to keep evidence of your relationship, right? Yes, most victims of abuse are not going to have traditional evidence the same way a happily married couple will, because that's part of abuse, right? They want to control you. They want to make sure that you don't leave the space if they don't want you to leave the space, which means they're not going to allow you to have financial freedom or financial liberty or whatever it is. But you want to document that stuff. Let's see what else. Another thing is, when you can, I 100% at this time, in the past, I would say, there's no, while they tell you there's no requirement for a psychological evaluation, I think that it helps to support your evidence when you don't have physical abuse, and the abuse that you're alleging is more psychological and more emotional. Another thing that I think will be helpful is going to be reaching out to victim advocacy groups in your state. That's something that, obviously, as I said, I'm just coming back to work. I'm still processing, the tragedy in my own family. But what I'm planning to do is I'm planning to kind of like create lists based on different states, or as many states as I can, like victim advocacy groups that you can talk to, or can direct you as a victim of domestic violence about, possibly rehoming you, rehousing you, homeless shelters, helping you with referring you to therapists, basically anything that we can use to support, what it is that you're experiencing with your abuser. What else did I want to talk about on here before I start answering questions, guys? Just give me a second, guys. And yes, one other critical thing that I want to talk about is that if you are a victim of trafficking, U visa, which is victim of a serious crime, VAWA, if you have a criminal conviction, understand, first of all, that a criminal conviction is different from a criminal charge. A criminal conviction means that they have found you guilty. If you have a criminal conviction, they are basically going to waive confidentiality. You don't have confidentiality protection anymore. What does that mean? That means they are going to look at derogatory information on the other side to make a determination whether you're a person of credibility, if you are someone that has a criminal conviction. So that is a key one that you guys need to know. So those are all the critical updates, I think, at least from my audience in the last 2 weeks that I wanted to provide clarity to. Let me go through and answer some questions. Tony's saying, is there a way to expedite a VAWA case? My case has been pending for 1 year and 2 months at Nebraska. Also, will contacting the Congress member for assistance have any negative impact on my case? So first answer the first question. First of all, 1 year and 2 months is not a long time. VAWA cases take 3 years. So you are very much in a normal processing time. The second thing is you can try to expedite it if you have, what USCIS considers an urgent humanitarian need. I will tell you that USCIS has been denying urgent humanitarian needs for expedite cases unless there is a need where your green card is necessary. So like if it's something where it's like, oh, I need to travel because this person's sick, or I need to do this because of financial or whatever it is, they will focus more, well, you have a work permit, or go apply for a work permit, and they're going to deny it. So that's what this new administration is doing. So you really, really have to have an urgent humanitarian need, to expedite your case or to get approved. You can expedite, you can try, but that's what we're seeing to get an approval. The other thing is contacting the Congress member for assistance. Does it have a negative impact on my case? If you have an airtight, this is how I look at it. If you know that you have all your ducks in a row, your case is solid, you shouldn't have any problem contacting a Congress man. You shouldn't have any problem filing mandamus. You're not eligible for mandamus, by the way, and you're not eligible for a congressional assistant, by the way. This is for you, Tony, based on your timeline. Those people, you're eligible for those if you don't meet, if they've not met the timeline published, or truly you have that urgent humanitarian reason. However, if you know you're not sure of your case and your case could go 50-50, personally, this is where I feel like non-adjudication is your best friend. Because yes, we have seen when people file mandamus and they don't have a solid case, they're very aggressive with their notice of intents to deny and RFEs and what they demand. So again, you can file, but you better make sure you have an airtight, solid case and every evidence. So whatever they throw at you, you can do it. Okay. Good morning. I know someone in Nigeria who has a visa and wants to get married here. Can he come here? She's an American citizen. So let me make sure I understand. So if she's an American citizen, why does she need a visa to come to America? I'm not sure I understand your question. Or are you saying that it's a Nigerian person with a visa to come to the US and they want to marry an American citizen? If that is your question, first of all, you cannot have immigrant intent, meaning you can't come here for the sole purpose of trying to adjust your status, because USCIS will say that it's immigrant intent, you're committing misrepresentation, or whatever it is. Now, if you come into the United States and 90 days after you've been here, you decide to get married to someone else, to someone and file, then that's different, right? But within those 90 days, it is not recommended to do anything that creates the illusion that you're trying to stay here permanently, because you could face another obstacle of proving clear and convincing evidence that that was not your sole intention, of coming here. Someone is asking, does this ban affect Nigerians waiting for green card interviews scheduled after the VAWA approval? So a reminder, this is not, if what your question means that you're talking about people here in America. There is no ban on the people in America. There is an adjudicative hold. It means there is a hold on the decision, approval or denial. There is a hold on that. This adjudicative hold will affect you if you are, so two things could happen. Your interview could either be canceled or your interview could be done, and they'll tell you that they cannot make a decision on your case. We've seen it both ways, where they were scheduled for an interview, they went to the interview, they said, obviously because of the hold, we can't make a decision on your case, we're waiting for the directives, or they can just cancel the interview. Again, we will know in 90 days what the new rules are and how they want to process those cases, all right? Okay. Giraffe says, I'm one of those countries and USCIS made an error on my EAD and I sent it to be corrected. Do you think they will fix it or is it still on hold? Honestly, your case is a little different from any of the exceptions. You basically, your scenario doesn't fall into it. So I can't really answer that question because in your case, it's not an adjudicative decision they're making because they already approved you for your EAD. They're essentially just changing the country, but I can't tell you because that's not one of the things that's listed as a scenario. Would cases move faster after the pause? I don't know. We'll find out once it's lifted. Someone is asking, does this affect I-751 cases? Can the individuals who travel come back? I talked about this, so you can watch it back again. I do have to jump off, but I am going to be live again tomorrow at 10 a.m. EST, Eastern Standard Time. So some of you, I know I didn't get to a lot of questions because today I just wanted to cover the new laws. So tune in basically tomorrow morning, and I'll also be live on Wednesday at 10, just as I'm playing catch up, and I'll be able to answer as much of your questions as I can. All right, guys, so I will see you all tomorrow. Bye.